I'm Işıl Aral from Koç University. On behalf of Manchester International Law Center, Garden Court North Chambers, Accountability Unit, and the Justice Hub of the University of Manchester, we are delighted to host this webinar, European Court of Human Rights, Navigating Turbulent Relationships with States, and our focus today will be on Turkey. I want to say a few words about the format. So right after me, Leto, our chair, she will introduce today's topic and she will also introduce the speakers. Each speaker will have around 7 to 8 minutes, and then we will have a Q&A for around 40 minutes. So please feel free to send your questions. Leto, would you like to take over?
Sure. Good evening to everyone. On behalf of Chambers, I'd like to welcome and thank our prominent speakers for agreeing to participate in our seminar today, as well as everyone who has tuned in to follow our discussion. I'm being told we have a great number of people joining us from literally all over the place, despite significant time differences, from Helsinki to Toronto, St. Petersburg, Bolton, Strasbourg, and of course, Ankara and Istanbul. Before we begin, let me briefly introduce our impressive panel. Michael Ivers, leading silk at Garden Court Chambers, former chairman of the well-respected Kurdish Human Rights Project and former treasurer of the Bar Human Rights Committee. Michael has extensive experience representing applicants before the European Court of Human Rights and has acted in a great number of applications against Turkey, including the Öcalan case. Ezgi Basharan, a well-known journalist from Turkey. Before leaving Turkey, Ezgi was editor-in-chief of the renowned newspaper Radikal. She's the author of a fascinating book exploring Turkey's relationship with the Kurdish people in the context of the broader Middle Eastern crisis, and is currently a research associate with the University of Oxford. Hassan Bakiji, one of the most talented lawyers working at the European Court of Human Rights today. Hassan quickly rose through the ranks to his current position of Deputy Section Registrar. And last but not least, Clare Ovey, who's also had a distinguished career in Strasbourg, previously worked for a great number of years at the Registry of the Court and is now the head of the Department for the Execution of the Court's judgments. Before I give the floor to our speakers, I'd just like to say a few words about the reason we're having this discussion today. Our seminar forms part of the Chambers series of seminars on international law, which explores the various implications of the narrative we're experiencing in terms of the breakdown of the rule of law from Britain in the West to Russia to the East. We're witnessing serious international and non-international armed conflicts raging in Europe, a relentless economic crisis with multiple effects and implications for the protection of human rights, the rise of terrorism, other forms of extremism and populism, to mention but a few of its aspects. Directly or indirectly, the court is being asked to deal with each of these issues. Gradually, as a result of recognizing the right to individual petition, the court has found itself playing effectively the role of what's been described as the supreme or constitutional court in Europe. It's expected to provide the last means of redress. It's the applicant's last hope for an effective remedy. However, while we acknowledge that the convention system is absolutely necessary and deserves our most committed support, we can also appreciate its inherent challenges and limitations. And these unfortunately become most apparent in situations engaging national emergencies. It's in this context we chose to discuss the situation in Turkey today, the gravity of which cannot be understated. And while it is regrettably not unique, it's become emblematic of the narrative of the breakdown of the rule of law. So the aim of our series is to encourage us, members of the legal profession in various capacities, to acknowledge its limitations and facilitate the dialogue necessary to generate concrete ways to strengthen the convention system. Now, I won't waste any more time and quickly pass the floor to Michael to give us an overview of the court's case law in the context of national emergencies. I'd like to encourage everyone to type any questions as we go along, and we'll deal with them in the Q&A session at the end. Michael, the floor is yours.
Thank you. Well, I'm going to deal with Article 15, obviously briefly, because I've got 7 to 8 minutes, and there's quite a bit of case law. And I'm going to do it generally rather than entirely focused upon Turkey, mainly because the case law about it doesn't come just from Turkey, but from many other sources. And indeed, many of the early cases come much closer to home here in the United Kingdom and Ireland as well, some of those early cases. Article 15, like most people who are on this are probably aware, provides a derogation from certain rights which are enshrined in the Convention in times of an emergency, effectively a war or a public emergency threatening the life of a nation. And it allows the state, in relation to a number of rights, to derogate from them, but only to the extent strictly necessary under the state of emergency, and only for a temporary limited period of time, and indeed in a supervised manner. There are certain rights which are non-derogable. The right to life in a time of war, the prohibition on torture. Indeed, often what the court does when you're arguing about non-derogable rights is to point out, to show how important they are, that they can't be derogated against even in time of war or a national emergency. I represented Inés del Rio Prada, a case against Spain in the Grand Chamber. It was concerning punishment without law, and the court made it, and the Grand Chamber made it very clear that when we're talking about those sorts of rights, ones where you can't derogate from, they carry, as it were, some extra weight, and indeed the court might look extremely closely because they're precisely the types of rights which can't even be derogated from. It's important to just remember a bit of the history here, that the convention was set up really from the ashes of the Second World War in Europe, and obviously lots of ghastly things had happened across Europe during the Second World War. Equally, people in the time when they were framing the matter, and in those years afterwards in dealing with Article 15, etc., were aware, and perhaps more closely aware than we've become accustomed in lots of the West, to the fact that states may face real difficult emergencies and face really difficult decisions about what they do in relation to actions which do threaten the life of the nation. So the first thing is the extent to which the court is going to actually interfere in the fact of a derogation, i.e. a government's decision to derogate. And the reality is that the court is very, very, very loath indeed to second guess when a government has declared a state of emergency. For evidential reasons, i.e. as has been stated in some of the case law, they're simply not in a position to know the facts on the ground in quite the same way. And of course, the derogation is essentially a political decision. And what hasn't developed is that the court have felt themselves able to displace the government's decision when it comes to a state of emergency. I suppose part of the political decision is, well, the fact is that if a country just wanted to leave, then the country could just leave. If the country wanted to just derogate all the time so that they're effectively leaving, then they could derogate all the time so they're effectively leaving. So the fact is they have a very, very wide margin of appreciation when it comes to their decision to derogate, and they have to notify the Strasbourg effectively of the derogation. The types of things which amount to facts which can lead to a derogation. In Lawless against Ireland in 1961, Ireland had effectively the IRA, who had a campaign, chiefly actually in Northern Ireland, but they were based largely in Southern Ireland, and effectively having as it was called in the court, a secret army engaged in unconstitutional activities and using violence to attain its purposes. The fact that this army was also operating outside the territory of the state just seriously jeopardising the relations of the Republic of Ireland with its neighbour, in that case, the UK. And the court accepted that there was a proper derogation in that case. Britain has, on more than one occasion, put in notices of derogation, notably in relation to Northern Ireland, and for a large period of time in relation to Northern Ireland, which got dealt with in the case Ireland against the United Kingdom. Turkey put in a derogation in relation in Alksoy in 1996 in relation to PKK activities. Again, that was a case where the court accepted the derogation. And more recently, again in relation to Turkey, in relation to the coup, as many of you will know, there was also a derogation put in then. The real progress for an applicant can be made not necessarily in second guessing whether or not the state should have put a derogation in, but the extent to which the state who derogating have removed their obligations only to the extent strictly necessary from the situation. And here the court are far more likely to examine very closely, well, this is your emergency, we take you, that you have an emergency, you need to take measures, but just what type of measures? How are you putting in place reasonable protections around the measures, bearing in mind that it's exceptional, so that the only the measures that are taken need to be only strictly what are required, having regard to the particular emergency. And in relation to that, the periods of time that people can be in detention for has come up on many occasions. Lawless and Ireland, again, Ireland and the United Kingdom, Brannigan, McBride and the United Kingdom. Frequently, it's about detaining people in circumstances where the government is saying that there's a national emergency. And those cases are dealt with by the court in terms of not just whether or not it was necessary having regard to the emergency, but also the extent to which there is put in place a structure to test things, the intervention of judicial authorities in relation to detention, etc., whether or not it's you can just let somebody be detained for 14 days, or why don't you come along with an explanation as to why you can't bring somebody before a court quicker than that, even in what you're describing as an emergency situation. So very much the court and the jurisprudence of the court in terms of Article 15 tends to hang in and around those decisions. And of course, before, I haven't really got much longer, but before I finish, it's worth saying that there are, of course, these significant areas where there can't be a derogation. The period of time is important. It's not something that's regarded as open-ended. It's only something that should be in place as far as strictly necessary. And those sorts of issues are matters which the court will take up, or has shown a willingness in the past to take up. And then just finally, interestingly, we've all been living through the COVID emergency, and indeed a number of nations have put in derogations in relation to the national emergency caused by COVID, and measures taken in those countries in relation to certain convention rights because of the national emergency that exists because of the pandemic. So I think my time's up, slightly more than I'm supposed to have had.
Thank you very much, Michael, for this fascinating presentation. I see we have a number of interesting questions. We'll deal with them in a bit. First, let me now give the floor to Ezgi to present the magnitude of the emergency measures in Turkey and its impact. Ezgi.
Thank you, Leto.
it's really good that I speak after Michael, because I hope I can give an overview of what we're experiencing and how it has not started with the emergency measures after the coup attempt. So there will be two parts to my talk, hopefully. First, I will give you this overview of the draconian measures in Turkey, and then I will elaborate on the critical junctures that led to this situation, which unfortunately dwindled from bad to worse. As you all know, now Turkey ranks in the Press Freedom Index in the 154th place, slightly better than the failed state of Libya. And according to Turkish Journalists Union, 50 journalists are behind bars as of today on the grounds of terrorist activity. As you have guessed, the terrorist label comes in handy for many authoritarian, semi-authoritarian, or competitive authoritarian regimes all around the world. So the sheer act of journalism, this is what we are talking about, searching for truth, has become grounds for being charged as a terrorist in Turkey and elsewhere in the world. Since 2013, 12,000 journalists have been tried for reasons related to their published works. Only in 2019, the sentencing of prison years for 59 journalists amounts to 200 years. Since the beginning of this year, 9 journalists were physically assaulted because someone felt offended by their work, because this is the climate that the journalists are living. So physical assault, fear of imprisonment, these are aside. The apprehension of getting laid off, getting sacked, had become another measure of censorship. For example, if a reporter's piece annoys a certain state official or someone in their entourage, it's a matter of hours, not days, that reporter in question would be sacked. According to Turkish Journalists Associations, at the moment, 30% of journalists registered are jobless. And if we consider the unregistered ones, the accurate picture would be amounts to doubling that number, probably. Similarly, hundreds of my colleagues are waiting for their press accreditations to be renewed for months, some of them for almost a year now. And it also applies to my foreign colleagues who needs to operate within Turkey. And as you can guess, the operation of a journalist is very limited if you don't have that accreditation. So undoubtedly, it was not only journalists who were affected by the government crackdown. After the botched coup incidents, almost 130,000 state officials, bureaucrats, teachers, and academics were dismissed by government decrees. 70,000 of them were academics. And 159 media outlets were shut down, again, by decrees. And in the last 7 years that Erdogan assumed office, it's before the coup attempt, as the president, more than 1,000 people were investigated, 40,000 people were tried, and 10,000 people were convicted of insulting the president. None of these people are in a position to apply to, for example, to the ECHR, because their cases are pending, but stalled. Therefore, their domestic legal processes are not exhausted. A similar systematic is applied to the academics purged by government decrees in the several years. So there are thousands of people who still do not know why they lost their job, but the ECHR declined to take a position, arguing that the domestic legal remedies are not exhausted. Unfortunately, this positionality may be legal, but it's not fair, and it reinforces the arbitrariness of the current judicial composition in Turkey. So this is the grim picture, where I can say people are exhausted by the crackdown, fear of reprisal, even for a tweet that supported peace talks with the Kurdish movement. You can be investigated in the morning. Your door might be knocked, for example, just in the morning of 5 o'clock. So how did we end up at this place that we did? First of all, again, the crackdown on journalists, press freedom, it did not start with the emergency measures in the aftermath of the coup attempt in 2016. I want to make this very clear to people who watch Turkey closely. It was in and around 2011 that the ruling AKP's authoritarian lurch, and more importantly, if you want to call it state capture, it is that in 2011 it started, not since 2016. So what is state capture in the context of Turkey? It is the loyal AKP loyal cadres, I'm not saying pious or religious, their cadres' gradual infiltration to state institutions such as the police, the judiciary, ministries, public education, and the purge of existing, usually statist and usually secular cadres from the state through sham trials of Ergenekon and Sledgehammer. So the AKP's authoritarian clientelist network, mainly consisting of conservatives and recently nationalists, are very similar to state capturing processes of Hungary, Orban's party, and Polish Kaczynski's party. I'm just saying these just to underscore that I understand the position of the EU and ECHR, while you have, you know, Orban and Kaczynski in your own turf. It makes it much much more harder for you to deal with Turkey. But I need to continue with the situation in Turkey. So the last nail in the coffin came with the initiation of the presidential system. So some people say, I mean, the proponents of this system, which I mean, ushered in 2018, the summer of 2018, they call it a Turkish style presidential system. Well, it has zero analytical and descriptive value. What is Turkish style presidentialism? What we're seeing here is either hyper presidentialism or authoritarian majoritarianism. The amendments that entered into force by the system in 2018 further centralized the powers in the hands of one single individual, the president, and they undermine all institutional checks and balances. This system gets away with the vote of confidence or vote of non-confidence by the parliament. One may, of course, say that this is normal in a presidential system. However, the system does not have almost any mechanism with which the parliament may hold the president to account. It is entirely sidelined. And as a drastic change in Turkish constitutional practice, the president may now adopt the so-called presidential decrees, even if there's no act of parliament that previously authorized him to do so. Finally, of course, there's the issue regarding the judiciary. One may be tempted to think that the most critical checks and balances may be provided by the Constitutional Court. Again, it is Erdogan or his party, AKP, in practice, who appoints the judges of Turkey's highest court, the last domestic remedy that ECHR points out in its every judgment. Therefore, there's no judicial authority, no parliamentary power to stop this ride into the abyss. The opposition parties and political figures are extremely cornered in all the sense of the word, especially the pro-Kurdish party HDP, whose MPs, including its co-chairs, mayors, are imprisoned. The party now faces being shut down. It will be tried by the Constitutional Court, whose unfortunate content I have just described. The sense of arbitrariness is pervasive and debilitating, not only for the legislative power, private sector, and the political scene, but also for society's everyday workings. All in all, this is what some prominent scholars of law in Turkey call deconstitutionalization in Turkey, a country, unfortunately, thankfully, with a 200-year-old history of modern constitutionalism. I think I will end here. I will be more than happy to answer any questions, especially regarding ECHR's and EU stance vis-a-vis this grim picture. Thank you.
Thank you very much, Ezgi, for this very brave presentation of the situation in Turkey. I'll now pass the floor to Hassan, and we'll deal with questions later on. Hassan.
Thank you very much. Good evening from Strasbourg, Leto. Well, let me say at the beginning that, as you know, Strasbourg Court is like a barometer of democratic governance, rule of law, and human rights in the member states of the Council of Europe. And an increased climate of intolerance, nationalism generates an increased caseload for the European Court. If you look at our current statistics or recent statistics, you will see that Turkey currently ranks second just after Russia. It is amongst the top 10 countries. And I don't want to give you a dark image of the Strasbourg Court, but I should like to say that we are under intense pressure and caseload. And we are already criticized by many people that we are not able to give a prompt response to the applicants who are turning to the Strasbourg Court for a prompt reply. But let me tell you what happened in the last maybe 2 decades in the Strasbourg Court in respect of Turkey. You will remember that in the 90s, where the Strasbourg Court had to deal with significant number of cases pertaining to the Kurdish people in the southeast of Turkey, such as burning of villages or extrajudicial killings and or killing of journalists. However, we passed that period, and when we arrived beginning of 2010, Turkey started doing significant number of reforms. And we were really hopeful that we would start doing some fine-tuning in respect of the Turkish law. But as Ezgi has perfectly laid out the view or the ground, as from 2011, the situation has started aggravating. And we started receiving a significant number of important human rights violation cases. But the turning point in this respect was the attempted coup d'etat on the 15th of July 2016. And it came as a shock to us. And immediately after this attempted coup d'etat, the Strasbourg Court has received, I would say, more than 40,000 cases against Turkey. It was like a tsunami effect on us. And we were receiving applications by trucks, literally. Like a few thousand applications were coming from people who were either detained or who were dismissed from their jobs. And all applications were similar. And in the face of such a huge workload, of course, we had to form some sort of a crisis management force. And we immediately set up a task force to deal with cases coming from Turkey. The vast majority of the applications brought to the Strasbourg Court were rejected for non-exhaustion of domestic remedies. Ezgi, of course, she criticized the court for being maybe naive, or she said it was unfair that the Strasbourg Court has dismissed those applications. But I should like to give you a little bit more of information why we did that. First of all, Strasbourg Court is a supranational court. It is not designed to deal with thousands and thousands of applications, given its limited resources. It is not its role, basically. So what we did, and also in accordance with the rules of international law, you need to give a chance to the respondent state, to the contracting state, to remedy any wrong. And in this respect, we selected some leading cases where we said that the applicants should first avail themselves of the remedy, the domestic law remedies. One particular issue was the people who were dismissed from their jobs. And those people were dismissed by decree laws. And decree laws simply said that these people were linked to the FETÖ organization, and there were no reasons whatsoever. So when we receive the applications, you look at the application form. The applicant says, for instance, I was dismissed from my job for being a member of this organization or for having been involved in this organization. It is unfair. I have nothing to do with this organization. And so they say, no, my rights, for instance, under Article 6 of the Convention or 8 of the Convention were violated. In such a situation, what could the Strasbourg court do? If we really proceeded to the examination of the merits of this case, all we would say was that the applicants were denied their right of access to a court because these people could not have access to the courts. So with the help of the Council of Europe, first of all, the government set up this ad hoc commission, which reviewed the situation of the people who were dismissed from their jobs. Because, when we received the applications, we didn't know why those people were dismissed. There was no single domestic decision other than the decree law. And at least now, when they go to the courts, the courts will have to examine their cases, starting with the commission, and then up until the Constitutional Court, and the Strasbourg Court will have something to examine, whether the dismissal was justified or not from the standpoint of the rights invoked by the applicants. So we also had a significant number of cases concerning alleged unlawful detention of journalists, MPs, or civil servants. And there are still some 7,000 cases pending at the moment. But in the meantime, the Strasbourg Court has delivered a number of leading cases pertaining to the journalists. For instance, I'm sure Clare Ovey will cover the situation of Kavala case, and she will be talking about it, or the famous case of Kavala or Mehmet Hasan Altan. And yesterday we delivered another significant, very important case in the case of Ahmet Altan, who was surprisingly released today, straight after our judgment. And it came as a very pleasant surprise to me just now. Our intention was to give priority to the leading cases in respect of different groups of cases coming to the Strasbourg Court. I do believe that given the limited resources we have, we did so far a good job, even though there were some delays. But you need to understand that we have very limited number of lawyers at the court, and we are not able to deal with thousands and thousands of cases arriving in Strasbourg. According to today's statistics, I can tell you that we receive 100 applications per day from Turkey. The detention cases slow down, but now we receive cases concerning the so-called FETÖ trials, meaning people who were put on trial after the attempted coup d'etat. Their trials are coming to the end. They go to the Constitutional Court, and then they are now coming to the Strasbourg Court. And we communicated some 10 cases which are likely to be leading cases, test cases. Once we examine those cases, we will decide what to do with the follow-up cases. More or less, this is what I would like to say. Perhaps maybe when we go into the questions and answers, I can give you more information about the court's reaction to different cases or complaints coming from Turkey.
Hassan, thank you very, very much for this extremely interesting analysis and background information about how the situation is in Strasbourg. I'll now quickly give the floor to Claire to explain in general terms the importance and challenges that are being faced in the course of the execution of the court's judgments. Claire.
Thank you very much, Leto, and thank you for inviting me to take part in this very interesting event. So I'll just briefly, I'll do everything briefly because we haven't got very much time, but I'll briefly outline the execution process and then give you some information on some of the key cases that we're looking at in terms of Turkey. The The execution system of the European Convention is unique in international law because it's supervised by a political body, which is the Committee of Ministers, which is comprised of representatives from the 47 member states of the Council of Europe. Having said that, it's in the first place in accordance with the principle of subsidiarity for the respondent state in a case where the European Court has found a violation. It's in the first place for the respondent state to propose the execution measures which it thinks are required. And the case law of the court and the practice of the Committee of Ministers is to the effect that under Article 46 of the Convention, which enshrines the binding force of the court's judgments, both individual measures, which are measures required to, as far as possible, put the applicant back in the position he would have been had there been no violation. So individual measures are required, and also general measures to prevent future violations for other people in the same position as the applicant. So it's in the first place for the respondent state to come up and inform the Committee of Ministers what measures it considers are needed. And then the Committee of Ministers will then, in the first place, the Secretariat, my department, and then eventually the Committee of Ministers can comment on those measures and give its view whether those measures are sufficient and whether more is needed to be done. It's a relatively transparent process. The Committee of Ministers meets 4 times a year to examine the execution of judgments for 3 days, 4 times a year. These meetings are closed, they're private, but the Committee of Ministers at these meetings adopts decisions which are made public. And the information that the committee receives from the respondent states, so the action plans and other communications from the respondent states, are all published. And there's a possibility for interested bodies, NGOs, international organizations, and also applicants to intervene by written procedure, and all of their comments are transmitted to the Committee of Ministers and studied very carefully by the Committee of Ministers. In terms of Turkey, I'd say it's quite a mixed picture. It's not a black and white picture. So of the 4,000 cases finding 1 or more violations that have been transmitted for execution so far in the history of the convention system, about 3,500 of those have been closed. We've heard already this evening about the Aksoy group of cases, which were a group of cases relating to very serious human rights violations, torture, extrajudicial killings, destruction of villages in the southeast in the context of the emergency at the time. And in fact, that group of cases was able to be closed last year in the light of extensive measures which Turkey put in place, particularly in the context of legislation and other measures to combat torture. And last year, the committee was also able to close, not in 2020, in fact, 2019, the committee was also able to close quite a significant number of cases against Turkey. But when we come to the more politically sensitive cases, I would say there are undoubtedly some major structural problems which have been pending execution for many years and where we're not seeing much progress. So of these, a significant group relates to freedom of expression, and the committee will be examining again the situation of freedom of expression, including the position of journalists, the detention of journalists, the criminal prosecutions of journalists. We've got a huge group of various issues to do with, a huge group of various issues to do with freedom of expression and freedom of journalists, which will be examined next by the Committee of Ministers at its next human rights meeting, which will be held in June. We also have a big group of cases on domestic violence. We have a big group of cases on freedom of assembly, and we're also looking at various issues to do with freedom of religion. Then the other cases which I'd like to highlight are the cases where the court has found violations of Article 18 of the Convention. And Article 18 violations are quite rare, thank goodness. These are cases where the court has found usually that the criminal justice system has been used in a way which constitutes an abuse of power, so that in fact abusive criminal prosecutions are brought, abusive pre-trial detention is imposed, where often there is not, there's no real offence that has been committed. There are no grounds to find that that a person has committed an offence and should be in pre-trial detention. We have 2 Article 18 cases against Turkey which are pending execution at the moment. The first and oldest of these is the Kavala case, and Osman Kavala it was a civil society activist who has been in detention for the last nearly 3 years. The court examined the charges which were pending against him at the time, which related to his role in the 2030 Gezi Park protests, and then also he was alleged to have been involved in the organisation of the attempted coup. And the court looked at these charges against him and found that there was not sufficient evidence to show a reasonable suspicion that he'd been involved in either of these offences. And the European Court found, in fact, that the prosecutions against him had been politically motivated to silence him as a civil society activist and to put a chilling effect on other civil society activists, and so found that the prosecutions were and his detention was politically motivated and was abusive. So the events after that, people probably know, he was in fact then acquitted on one of the sets of charges related to the Gezi Park events. And then the same day he was re-arrested, and he's now in detention pending charges of espionage and giving state secrets. We have had, his case has gone up to the Constitutional Court. We've had the Constitutional Court's judgment, which you can find an English translation of that is published on the on our website. I should say, if you're looking for any of this information, we have a very good database search engine called HuDoc.exec, which is similar to the court's HuDoc database, where you can search by case name and by keyword. And so you can find, if you search for Kavala, you can find the Constitutional Court judgment, which we've got an English translation of published there. This was a judgment which was adopted by a majority of 1, and in the dissenting group there were the President and the Vice President of the Constitutional Court. The majority found that Kavala's present detention is lawful. The minority said that it's in fact based on exactly the same evidence as was examined by the European Court and found by the European Court not to provide a sufficient basis for detention. This case, as I say, is pending before the Committee of Ministers. The committee has decided to examine it not just at its quarterly human rights meetings, but at every single meeting. So it usually meets, the committee meets basically once a week. It met today, as I say, we'll probably adopt further decisions in this case. The Committee of Ministers doesn't have a huge amount of tools at its disposal in the case of a failure to execute a case. I should say, in the context of the Kavala case, the committee has been, ever since it started examining the case, has been calling for Kavala to be released. And it was in the light of Turkey's failure to release Osman Kavala that it decided to take the case exceptionally at all of its meetings. If Turkey continues to refuse to release Osman Kavala, as I say, there are very limited tools available to the committee. In one similar case in the past, which also was another Article 18 violation with against Azerbaijan, with someone who was could be described as a political prisoner. There, the Committee of Ministers used its ultimate tool, which is to send the case back to the court for infringement proceedings. And the court found that the failure to release and to quash the conviction of Ilgar Mammadov did amount to infringement. Once the court has made such a finding, then the case comes back to the Committee of Ministers, and the Committee of Ministers then has to really decide if there's still failure to execute the case, whether to keep the state within the Committee of Ministers. Within the Council of Europe, it can suspend the state's membership, but that's really the ultimate nuclear bomb sanction. So I think I'm completely out of time. So I will stop talking now, but I'm happy to answer any questions. Thank you.